Welcome back to the show. Many thanks for staying with us. Well, now that we have a judgment from the court, there is a need for peace and cohesion, which is paramount, and political parties are major stakeholders in keeping that peace. In a communique issued at the end of the third consultative meeting by the Ministry of National Security, the New Patriotic Party and the National Democratic Congress, the political parties involved in this, among others, committed to the need to preserve the peace in the aftermath of the judgment by urging their supporters to exercise restraint and desist from any provocative acts that could undermine law and order. So how do the parties ensure that their supporters actually work to preserve this peace we're talking about now that there is a court ruling? I'm being joined in the studio by Faisal Ibrahim. He is a lawyer and also a member of the legal communication team for the second respondent, President Akufo-Addo. We're expected to have a representative from the petitioners team, but we're not getting through to them at this point. So let me just start the conversation. Just so you know, Bobby Banson, who is also a lawyer, will be joining us in this discussion. Bobby, are you there? Okay, he'll be joining us shortly. Faisal, let me take you're welcome to the show, by the way.
Thank you.
Let me take your initial reaction. I'm sure it's excitement, but perhaps you add the sort of talk that has been going on among your team after.
Well, I would say it's an exciting news, but it's also expected for anybody who was objectively observing what was going on in court. Even those who didn't have maybe some legal mind, you still couldn't have expected anything better than what the Supreme Court has delivered. And it's instructive to know that they spent close to 2 hours and they gave valid, grounded legal reasoning for the ruling or the judgment which they delivered. Every argument that have been raised by the petitioners were properly dealt with. The authorities were cited to show why each one of them didn't merit the reliefs that they were seeking. So we are excited by it, and we believe that the strategy that we used worked, and it had to work, because if you observe what was going on, I have said on many platforms that the star witness, Honorable Asedun Kitia, anybody who had spent some time to listen to the cross-examination conducted by lead counsel on our side, the very effective, dynamic senior Akoto-Ampao, if you watch the cross-examination clearly with an objective mind, there's no way you could have said that the petitioners hadn't fallen foul or fallen flat with their case. Because
you're saying it makes you excited, Faisal, because it's went in your favor, obviously. But on the basis of the, when you say that if you were objectively observing what went on, especially with the star witness for the petitioner, then you wouldn't have expected any other conclusion. But then the court also held that there was the petition disclosed reasonable course of action. So it's not as if there was no merit completely from the start.
I think by what you just asked, you may be mixing two issues.
Okay.
The first issue for the court to determine was whether there was a course of action. And that is a preliminary legal objection that we raised. And the rules CI 99 allows for respondents in the matter to file same. And we submitted our legal arguments. But the court said, well, in view of the fact that, one, the petitioner is making an allegation that the EC didn't follow certain provisions of the Constitution, clearly it's a constitutional matter, and so you cannot say that because there is some weakness in the argument that he's making, and so we shouldn't go into it. Yeah. So they based on, they made their ruling on that particular issue based on the fact that it is an allegation of provisions, an allegation that some provisions of the Constitution hasn't been followed.
That
required for them to go into it. The fact that you've looked at it and you assess and think that what they are saying is weak shouldn't be enough. So that's the reason why they went into it. But as far as
which is why I said that, because of what you said, that if you were following objectively, you would know. It sounded to me as though you're supposing that, well, like many people have said, we shouldn't have been in court at all. The NPP's John Boydu, for example, says this was a waste of time. You
see, so that's why I needed to show the difference between the two.
Help me out.
The second part, which is the petition proper, Why are we in court? We are in court because, one, the former flag bearer of NDC for the 2020 election had said that nobody obtained more than 50% of the valid vote. That is why we are in court. And that is the allegation. That is the primary issue for the court to address. So if you say so, then it's an obligation on you as the person making that allegation to produce evidence to support that. That is the simple work you are supposed to do. Okay. If you fail to do that, and your own witness comes and he's given a Makola calculator where he churns out figures and he keeps declaring at every point in time that Nana Addo Dankwa Akufo-Addo is the one who has obtained more than 50% of the valid vote, then clearly means that you shouldn't have even come to court in the first place. Okay.
I will, let me bring in lawyer Bobby Banson into this conversation, but I need to also once again say that we were expecting representation from the petitioners' camp. We had made prior arrangements, but as of now, there hasn't been a response to that. Lawyer Bobby Banson is joining us. Bobby, thank you. Good afternoon.
Good afternoon, and thanks for having me. Sorry I missed you earlier.
No, that's okay. I'm sure that you are following the argument that Faisal here is making. Essentially, we wanted to focus this conversation on building the national coalition towards development, going forward with what has happened, how we can work, to get the supporters on board. But we're just taking thoughts or initial comments on the process so far. His point, which has been underscored by a lot of the his NPP colleagues, is that we shouldn't have been in court in the first place, and that is a total waste of time.
Good afternoon, Faisal. We've not spoken for some time.
That's right.
So I take it to mean that Faisal is representing the respondent, the second respondent.
He is.
Okay, that's good to know.
Is there something we should know that we don't know?
Okay, if I may, he was my TA, my lecturer at Ghana School of Law. Okay. So I'm sure he's proud to have.
You're proud to have your student there.
Yes,
all right.
I'm proud to have my student sitting there.
Very well. Okay, anyway, please go ahead.
Well, I do not completely subscribe to the notion that the petitioner shouldn't have gone to court in the first place. You would realize that after the results were declared, tensions were very high in the country. And I think that it was wisdom for the petitioners to have decided to go to court and then informed their supporters that, listen, we are in court, let's trust the process. And I believe that allowed a lot of the dust to settle. It was able to diffuse a lot of the tension so that we will follow the process. Unfortunately, or the truth is that the moment the petition was filed, and the pink sheets, as they've come to know, the evidence were not attached by the petitioner to show exactly the figures that they were relying on, then you realize that they had a problem. Because you see, you go to court, the burden of proof is on you to prove on the balance of probability in a civil matter, that indeed your case is more likely than not. The Electoral Commission, which is the respondent in this case, they have declared the results using the pink sheet that they said was available to them. If your case is that the figures turned out by the EC's reports or declaration is different from the figures that happened on the ground that were on the pink sheets, then the burden will be on you to provide evidence contrary to what the EC had declared. And these pink sheets were available to the NDC from the beginning because they had representatives at every single polling station. They signed the pink sheets, and from 2012, that was one lesson that we all learned, that elections are won or lost at the polling station. And so if you are not able to provide the evidence or you sign onto the pink sheets, then unless you are able to prove any form of illegality or fraud, then you are stopped from alleging something that is different from what is in the pink sheets. And that was the big lesson from the 2012 election petition. And so once they filed their petition without attaching those pink sheets that would show figures that were different from what the Electoral Commission had declared, then every objective person knew that they had a difficult challenge to surmount. And that is why you would see Mr. Chachu Tikata, the very seasoned senior lawyer, trying all sorts of means to make sure that they would have the EC or they would have the pink sheets brought as part of the evidence. So you realize that he filed an application for discovery, which he lost. He filed an application for interrogatories, which he lost. He filed a request to admit facts, which were not presented, which was not responded to. All these were attempts, and his last attempt to have the Electoral Commission chairperson subpoenaed so he could cross-examine or examine, as it were. And these were all attempts to adduce evidence later on after the matter had begun. And you see, because of the rules that govern the election petitions, you could not amend your petition once you file to change the basis of your case or to introduce evidence which was not hitherto accommodated by your pleadings, contrary to normal civil actions.
Yeah.
And so the petitioner then had a very difficult task. Once they filed the petition and laid the foundation, they did not attach those evidence. It was very difficult for them.
So, Bobby, let me just jump in here. We took some reactions from across the country, and we were hearing from ordinary Ghanaians what their thoughts are. Some of them indicated that, well, they're happy we're here, but then they thought it would have been good for the entire country to have someone like the first respondents chairperson in the box to explain to Ghanaians what actually happened, to set everybody else's minds at ease. I mean, this is a legal matter, but in the court of public opinion, wouldn't that have been a better option, as we've heard some of the people say?
You know, the law courts are governed by rules. They are governed by statutes. They are governed by case law. Justice is not administered in a vacuum. Justice is administered within the ambit of the law, so that there will not be uncertainty with what is justice and what is not. So if you decide to ventilate your grievance using a particular procedure laid down by law, then you must abide by all the terms of that procedure. And that required that if you go to court to allege any fact, the burden is on you to prove. Now, we should remember that the EC was not on trial for administrative errors. And I think that we must make that very clear. The EC was not on trial for administrative errors, because you cannot go to the Supreme Court and then say that there were administrative errors by the Electoral Commission, so the EC should declare as such. Sorry, the court should declare as such. No, you went to court because your position was that presidential elections have been conducted. The results that were declared are not the results that you had, or are not the results that should have been declared.
Okay.
And so you have to come and tell us what the results that you had, or what, in your opinion, were the results that should have been declared are, before you expect the EC to come. Because remember, in terms of how the EC conducts their operations, there is a body that does that, and that is the inter-party, what's the name? They meet with the Electoral Commission once in a while, made up of representatives of all the police. The IPAC, yes, the IPAC. That is where you resolve administrative grievances, not in the courtroom, more so in the Supreme Court. So I understand the common sense approach, let me put it that way. And people thinking that, oh, it would have been fidelity to common sense if the EC commissioner was put in the box. Was put in the box to do what?
Okay.
To say that, okay, this is how we conducted the elections, pink sheets are signed, they are transferred. All those things were put in an EI, which were passed by Parliament, upon, submission by the Electoral Commission, before we went to the polls.
All right.
So those who have that inclination that there was an administrative malpractice, the Supreme Court was not the fora, or the forum for to ventilate that grievance.
Okay, I'm just going to, I understand you have to go and teach, so I'll just I'll just end it with you here. But I just need to indicate that lawyer Kojoga Dawudu is joining us for the NDC, or the petitioners team. But Bobby Banson, thank you so much for your time. Bobby Banson is a lawyer who joined us with his thoughts. I still have Faisal Ibrahim here in the studio, but let me welcome Mr. Kojoga Dawudu. Hello, Mr. Dawudu, can you hear me?
I can hear you.
Okay, great. Good afternoon, and thank you very much for your time. Your team today was extremely brief, about 20 seconds. What's going on?
I think that what we have been saying will be said by the former president this evening, and we didn't want to be a precursor or say what he's supposed to be saying, to take the shine out of what he would say. So that is what we are all waiting for, that at 5 o'clock we will hear the former president speak on the issue. In all, we are not too much surprised as the way things turn around. However, I think one of the consolation or things that we take is that when people were saying that we have no case, there is nothing, there's no cause of action, I think it was made clearly that you can challenge the validity of the election. And if there is validity of the election, it is the constitutional instrument that has been made. That is what you would see as prima facie as the election. And that's what we were saying, that it was not done properly. For us, I think everybody is clear that, yes, we had a case, we took the case. It is the view of the Supreme Court that we did not demonstrate or did not have enough evidence. That's why they are dismissing the application. Now, the no side for me, and maybe for the team, is that we didn't, Ghanaians have lost, and I think have lost some reforms that would have been made if all the parties were able to say, or the electoral commissioner, the chairperson, would have told Ghanaians the process by which she was able to go through to come out with the PI 135. It will, even if they are saying that we are talking about the administrative things that they are talking about, that it shouldn't be the fora, I don't think that that is the essence. We did not say that it is administrative error. We are saying that there were error. There was no collation. So
and the Supreme Court, the Supreme Court is saying that you have not been able to prove the point.
Yes, but if the Supreme Court says that we are not able to prove, right, what I'm saying is that, so that means that we are not going to have any reforms within our electoral commission until that will happen.
What kind of reforms? What kind of reforms were you expecting that this petition, for example, would have brought about?
Let me give you a typical one. Is there any time for collation after election when the polls closes at 5 and the results start trickling in? Is there any time frame for collation? There is no time frame. And one thing that I have picked from this election means that when I go to the collation center or polling station where the results are being declared, I won't take any instruction from any person, administrative person or official who is erring. And that will mean that if he will not also listen and do the right thing, we'll have to settle it down there.
Okay.
We will settle it there. We won't even go anywhere again, because it is my duty to make sure that I am there and I'll have to perform my duty. So any errand or erring administrative officer, returning officer, like has happened in Tesima, nobody's going to take it and say that we are going to respect the rules of the law and say that we will take it for administrative to be resolved or to take it to the court. That is one of the things that we should have spoken about it and have reforms as to when it will happen.
Let me just bring, hold on for me, let me just bring in Faisal Ibrahim, who is a member of the legal communication team for the second respondent. Faisal, so the point he's making is that we have just missed out on a real clear opportunity to work out some election or some electoral reforms.
You see, it is one of the arguments that they keep bringing up. And I keep saying that if the petitioner had discharged the burden on them, they did not need to compel even the EC chair to mount the box. That point must be made fundamentally clear. I'm saying, and I'm repeating, if the petitioner had been able to adduce evidence to support their petition or their allegation or the pleadings they filed in court, they didn't need the EC chair to compel the EC chair. The EC chair herself would have mounted the box to explain herself.
But how does that address the issue of electoral reform?
I'm saying, no, it's a step. Because from what he's saying, if she had mounted, She would have said certain things. Then the judge would have gone in and come to give certain advice. Then there will be reforms. But the point is, seeking reforms is not why you go to the Supreme Court under Article 64(1). If you want to go to the Supreme Court under Article 64(1), there's no way that it says that if you need reforms in your electoral system, go to Supreme Court.
But there's precedent to the effect that
that's exactly the point I'm saying earlier. So what we did was, because we went in there with over 11,000 pink sheets, and we challenged the validity of the election. They went to challenge the validity of a declaration. There are two different things, and the court made it clear today in the judgment that what they are seeking is not what we came to do in court. And so when we finished ours, then the court had to then go in, because there were errors, clear errors that was made patently clear in court. So then the court started giving advice. Okay, do this, make sure you paste the pink sheet at the place, make sure everybody has a copy. Because
you agree that we have lost out on an opportunity to it sounds to me that you agree that we have lost out on an opportunity to make or implement electoral reforms, but you do not you think that that's the fault of the petitioners because they didn't go in a way that would have allowed that to happen.
I'm saying two things. One is that if they had discharged the burden, then the EC chair would have mounted the box and explained certain things.
Okay.
And if there were any reforms that was needed at all, then maybe the ruling would have, or the judgment would have captured same.
Okay.
But I'm saying to the extent that you didn't discharge your burden, don't go blaming others for the failure on your part. That is one. Then you also asked, he also made the point that I wanted to know the process that she went through in declaring the results. I'm surprised.
She used that as an example.
No, I'm surprised. Because you see, we're all going into the game with a set of law. That's the CI 127. CI 127 spells out at every stage what needs to be done at the polling station, at the constituency coalition center, at the regional level, then at the national. And this is codified. It went to parliament. We all know. So if you say now you want to know how she did her work, just read the law. And she had also told you in her response, her answer to your petition, that she followed this law. So what you needed to do was to bring evidence to show that, oh, this particular law wasn't followed. And you failed to do that.
Okay. Lord, that will do. Let's wrap this conversation up. I don't know if you want to say something on the back of what he has just said, but one of the key things we wanted to address in this conversation is the way forward. What next? And how do we consolidate the peace we have in this country, national cohesion, etc.?
The second and third witnesses said was fanciful. But what they are trying to say is that at the collation center, was there a proper collation? This is what happened. The law says there should be collation. It wouldn't have happened in Petition if there was a proper collation. It wouldn't have happened in Sefibi also. It wouldn't have happened in Takwa. It wouldn't have happened in Zabzuku, where there would have been a proper collation. And that's what they are saying that. So I asked the collation. So everybody knows the law. The law is 127. Whether it was applied properly or it was not applied properly. That's what we are talking about. But I am saying that even if the Supreme Court itself would say that you went there and you did not do the work or serve the interest of your principals, it means that the next time people would be alert and would be out of reason when somebody is erring. And that is what we have lost.
Okay.
Two, it is the law, they have spoken. Yes, we agree with some, we disagree with some of it. And at the end of the day, I think that it is just that it has been reaffirmed that when you want to win the election, go there. Now that we are also having issues where at the polling station and collation center, we are having the security and others coming in. And once they come in, there is chaos. I'm sure that people will be prepared that when they are going the next time, they would also be armed and make sure that nobody comes in to snatch or...
Well, that is not to suggest that you are promoting lawlessness during elections.
No, it's not lawlessness.
So while you answer that question, Mr. Daudu, kindly address this issue for me. What next? How is the party, your team, your lawyers, etc., going to harness the support of your supporters who were initially agitated because they believed, based on what they had heard, that they had actually won the election and it hadn't been given to them. Then the way forward, the next steps.
There is one thing the court will look at as evidence and say, and there's one thing on the ground. Maybe the court says we have not demonstrated, so we did not take enough evidence. That's not take away that, yes, in their belief and what happened on the ground, and they have seen, would means that yes, what the court has said is conclusive, yes. But in their opinion, it doesn't mean that they have lost the election. They know what happened on the ground, and we will speak to that. And I'm sure when the former president speaks, you address some of the issues. Okay.
I'll come back and take your final thoughts on this. But Faisal, national cohesion. We have seen, I spoke to my colleague Elton Berber, who was at the presidency. He said there was no celebration, nothing like, just, people talking to each other and showing a bit of excitement, and it was business as usual. We heard Samir Uku say, well, whatever you're doing, do it, modestly, etc. But then, is there a clear plan to make sure that people don't rub things in other people's faces towards national cohesion?
Well, one thing about going to court in an adversarial system is that there is no draw. There's always a winner and a loser. But it's the conduct that you exhibit, either as a loser or a winner, that shows whether you want peace. I will also use the platform to urge our side, especially in this victorious time. We are supposed to jubilate. I mean, the coronavirus cannot stop us. And if coronavirus cannot stop us, then clearly it means that we are within our right to jubilate. But we should not jubilate in a manner that will incite some anger or in a provocative manner. But it's important that I stress that the fact that you've gone to court doesn't mean that the matter which you took to court is true. Sometimes people go to court for various reasons. And I heard one of the persons who were interviewed in Ashanti region saying that he believes that maybe the petitioner went to court maybe to sustain his political career for a period or to excite the base. Well,
that's a position that you of the NPP have been making for
it shows that because the interview you did, the person you interviewed, you cannot say it's a political person. This is an ordinary man who is airing his...
It's possible that they're also political.
Well, to the extent that you didn't introduce a person as a political person, I cannot sit here and say that he is. But this is what the reasonable mind is saying on the street. Is telling you that he believes this petition was filed because he wants to sustain a certain excitement and love, and possibly what's going to take place at 5 o'clock. From what he said, that the former flag bearer for their 2020 elections is going to address the nation, or is going to address us or his supporters at 5 o'clock.
What you're talking about, what you expect to hear from him?
Well, I'm saying that it is likely to fall in line with the suggestion that came from the Ghanaian who you interviewed earlier, that this is really a political gimmick, possibly to sustain the career of maybe the petitioner.
So what are you expecting to hear from the former president?
Well, like I said, I mean, we have politicians. For instance, one, that he disagrees, two, that he accepts, that three, he will need some time to reflect, that four, when he decides what he wants to do with his political future, he will find the time.
That's what you're expecting to hear from him.
To tell Ghanaians.
I see.
Yes,
and what are your other members, your legal team members going to, what kind of conversation are they going to have with the president? We're told that will happen at the same time that the former president is speaking.
Yes. In fact, I left a meeting that was taking place earlier, and those discussions came up. But clearly, this is going to be between the lawyers and then the client. So they're going to meet with him and share the good news, and then we'll see.
I see. Lawyer Dawodu, let me take your final thoughts as well, your final comments, if you'd like us to know what to expect when the former president also makes his address, that'll be fine.
Oh, no, I would only say that, yes, the court has declared and has thrown the petition away and said the second respondent, His Excellency Nana Akufo-Addo, was validly elected. I think that he has an honor tax on him to make sure that there will be cohesion in this country. We can come together, because you can have a beautiful judgment, you can have judgment in your favor, but it might not bring reconciliation. You go to court, you have judgment, doesn't mean that there's reconciliation. So I'm sure that there should be a way that he should engage. He should consult and engage the people that really, that if he wants to leave an impactful legacy, and whilst he has finished his term, he should say that this is what I've been able to do and bring the people, but not that the people will be more divided on political and other social lines. I think for me, that is what as Ghanaians we need to be looking at, because you can see that we are getting more polarized. We need to make sure that that social cohesion will be there.
Okay. Okay, gentlemen, thank you so much for your time. Lawyer Kojoga Adaudu there is a member of the NDC legal team who joined us via phone. You want to make a comment?
Just a very last one.
Okay.
That in elections, when you're sending agents, ensure you're not sending agents who have a thirst for tea. It's likely to affect. It's one of the issues that came up.
Well, I'm sure
today. And then the last one, that President Nana Addo Dankwa Akufo-Addo was validly elected at the 7th December 2020 elections. He's the president. He's going to serve us for the period. So far, he's fighting the COVID so well, and we are supporting him. And I'll use the opportunity to urge Ghanaians to also support him to deliver for the second term. Thank you.
Faisal, thank you very much. Lawyer Kojoga Adaudu joined us on phone. He's a member of the NDC legal team. I also had here Faisal Ibrahim, who is also a lawyer and a member of the legal communication team for the second respondent, President Akufo-Addo. Thank you very much for coming once again.